Please be seated. The sitting is open. The court meets this afternoon to resume hearing the second round of oral argument of the Gambia. I now give the floor to Ms. Tahfadwa Paspanodia. You have the floor, Madam.
Good afternoon, Mr. President, distinguished members of the court. Myanmar's core submissions in response to the discriminatory laws and policies targeting the Rohingya are that they are immaterial to genocidal intent, that the 1982 citizenship law is not materially different from the 1948 framework, that restrictions on marriage, birth, and legal identity were limited and non-suppressive, and that segregation, confinement, and movement limitations cannot evidence genocidal intent. The record, including witness NJ's testimony, shows otherwise. The court heard witness NJ explain that although born in Rakhine State to parents, grandparents, and great-grandparents who lived in Burma, she had no citizenship, no birth certificates for her children, and was pressured to accept a national verification card branding her a foreigner. When she refused, authorities denied her schooling, movement beyond her village. Authorities compelled her and her husband to pay a bribe to be able to marry and made them pledge not to have more than 2 children. In August 2017, soldiers came to her house, beat and killed her husband and father-in-law, stabbed and killed her 2-year-old son, gang raped her, and burned her home and village. She fled to Bangladesh and has never returned. The acts suffered by witness NJ are the foreseeable result of a state system designed and enforced to destroy the Rohingya in whole or in part. Under this court's jurisprudence, intent may be inferred when the cumulative pattern admits no other reasonable explanation. Moreover, tribunals have held that prohibiting marriages and preventing births are genocidal measures, and that deliberately imposed living conditions that, quote, ultimately seek the death of the group, deprivation of food, medical care, shelter, and movement, also constitute genocidal acts under Article 2C and 2D of the Convention. And history confirms the relevance of genocidal discriminatory laws and policies, from Nazi legal denationalization and segregation to Rwanda's identity card regimes. Such laws and policies were found to be paradigmatic measures that paved the way to physical destruction. Mr. President, Myanmar's council conceded that the Rohingya constitute a group protected by the Convention. The Rohingya have a long and documented history in Rakhine State. Moreover, Myanmar's council did not dispute that in the decades following independence, the Rohingya belonged to Myanmar's polity, that the highest government officials publicly recognized the Rohingya by name and as, quote, one of the ethnic races of Burma, that Rohingya served in public office, and that the Rohingya language was used in public broadcasting. This matters because what followed was a deliberate re-engineering of the polity to exclude and erase the Rohingya. Myanmar's council contests this by asserting that the 1982 citizenship law is not materially different from the 1948 one because the latter also referred to certain ethnic groups. But the laws themselves show a decisive legal pivot. The 1948 Act referred to indigenous races only to define the term's use in the Constitution, expressly extending the concept to any other racial group that had settled in Burma before 1823. More importantly, the 1948 framework established broad race-neutral routes to citizenship for, quote, any person whose ancestors for 2 generations made the Union their permanent home and whose parents and self were born there. By contrast, the 1982 law fundamentally reoriented citizenship around, quote, national races and a strict jus sanguinis regime, designating members of national races as citizens by birth and relegating others to downgraded associate and naturalized categories, and authorizing the state to determine which ethnic groups are, quote, national. Myanmar has not disputed that the national races defined in the 1982 law were later subdivided by military instruction into 135 groups from which the Rohingya were excluded. Council for Myanmar's suggestion that the associate and naturalized citizenships are not inferior is incorrect. The 1982 law subjects these categories to rights which may be curtailed, quote, from time to time, imposes onerous discretionary entry criteria, and does not provide for the automatic transmission of citizenship by birth to their holders' children, among other differences. These provisions, combined with the 1982 law's authorizations that authorities need not, quote, give any reasons in matters carried out under this law, enabled systematic exclusion. The resulting statelessness of the Rohingya, which Myanmar does not dispute to be on an unprecedented scale, is the predictable effect of the 1982's law and structure and implementation. Nor has Council for Myanmar denied that hundreds of thousands of Rohingya were forced to flee to Bangladesh following an operation for, quote, scrutiny of illegal immigrants in 1991 and 1992. Myanmar's council simply dismisses reports by UN institutions and NGOs of military violence without providing any evidence, and invokes later repatriations as inconsistent with genocidal intent. But repatriation under international pressure does not negate intent. It sits alongside evidence that the state repeatedly deployed force to destroy the Rohingya of northern Rakhine State and repeatedly re-engineered law and documentation to deprive and erase those who remained. Myanmar's council also argues that NVCs are a neutral step in verification.
Council, could you slow down a little bit? The interpreters are having a problem.
Thank you, Mr. President. Myanmar's council also argues that NVCs are a neutral step in verification, and that difficulties claimed by Rohingya are speculative or self-inflicted through refusal to apply. But Myanmar's council accepts that NVCs do not evidence citizenship and in fact confirm foreign status, that applicants cannot record Rohingya identity and must accept the label Bengali, and that those without NVCs face movement barriers. The UN fact-finding mission explains that on the ground, the citizenship process for those belonging to the national races was expedited, while the Rohingya were shunted into a protracted and coercive track. One of the state pamphlets circulated to the Rohingya is on the screen. If you want to do fishing, apply for the NV card first. For social and economic activities, hold the NV card. To have guarantee of life, keep NV card together with you. To have guarantee of life, keep the NV card together with you. As witness NJ explained, she refused to accept an NVC that branded her a foreigner in her country of birth. I quote, "That card says we are not nationals of this country. That's why we didn't accept it." Witness NJ also explained the deprivation and risk that resulted from the decision not to take the NVC. I quote, "We were not allowed to go outside, anywhere else within our township. If we went, if it was found out, then we were beaten, we were tortured." Contrary to Council for Myanmar's assertion that Rohingya could attend school without an NVC, she testified, I quote again, "Myanmar military didn't allow us to attend any school." The insistence on erasing a group's very name while conditioning survival on accepting foreign identity is an indicator of genocidal intent recognized by the UN fact-finding mission. I turn now to the suppression of family life and births. Council for Myanmar concedes that Regional Order 1/2005, adopted for the express purpose of, quote, controlling the Bengali population for the good of the region and the race, was in force between 2005 and 2018. He says, however, that the regional order was neutral, did not state a specific limit on the number of children, and that there is no evidence a two-child limit was ever strictly enforced or effective. Members of the court, witness NJ's experience is the lived imprint of that regional order. In response to questions from the court, she explained that she was forced to pay a bribe to get married, sign a paper not to have more than 2 children, and even had to hide one of her twin children from inspections or risk fines and imprisonment. Myanmar's council's denial of the existence of a 2-child limit for the Rohingya is also belied by Myanmar's own spokesperson, who acknowledged the limit in 2013. Myanmar's council also asserts that there is no evidence of weight that these orders suppressed births or led to abortions. Its efforts to discount the UN fact-finding mission's reports and an extensive reproductive survey across 9 village tracts conducted by Médecins Sans Frontières while offering no independent evidence of its own is unpersuasive. Myanmar's council did confirm, however, that Myanmar generally failed to provide Rohingya newborns with birth certificates from 2012 to at least 2017, and only intermittently since, although the Gambia's position is that this practice dates back to the 1990s. Myanmar's council's attempt to justify this failure, invoking riots over a decade ago, the COVID pandemic, or the Rohingyas' alleged lack of awareness about registering births, is not convincing. There is no evidence that the provision of birth certificates to newborns of any other ethnic group who would be equally impacted by those factors has been similarly affected. Witness NJ explained that in her experience, the Rohingya are never given the opportunity to obtain birth certificates for their children. Consequently, there is no official record that her 2-year-old son, whom the military threw into a burning house, was ever born, let alone that the military killed him. The same can be said of the children of witness MS and the multitude of other Rohingya children who were killed in the clearance operations, but whose birth has never been recorded by Myanmar. The UN mission summarizes the consequences. Denial of birth certificates, quote, deprives Rohingya children of a permanent record of existence and legal identity, and negatively impacts their access to health, education, and other services. Taken together, these measures are calculated to suppress Rohingya family formation and births and to erase legal personhood, precisely the sort of conduct tribunals recognize as probative of genocidal intent. They are genocidal. The discriminatory laws and policies targeting the Rohingya culminated in the clearance operations and have continued since. Myanmar's council did not refute that following the clearance operations, Myanmar pursued demographic replacement in Rohingya areas, establishing Buddhist model villages on Rohingya land, announcing that the Rohingya would not return to their original villages, and encouraging, facilitating with documentation, and sponsoring with living stipends the settlements of Buddhists from Bangladesh into Rohingya majority areas. In conclusion, Council for Myanmar indicated that not all discriminatory acts are genocidal, but that's not the issue. The court must determine whether genocidal intent is the only reasonable inference from the acts considered together. The discriminatory acts and architecture I have described reflect a genocidal intent and contributed to the genocidal acts that followed. Mr. President, members of the court, thank you for your kind attention. May I respectfully invite you to call Mr. Suleiman to the podium.
I thank Ms. Paspanodia for her statement. I now invite Mr. Arsalan Suleiman to address the court. You have the floor, sir.
Mr. President, members of the court, good afternoon. I will focus on why Myanmar's anti-Rohingya hate speech and propaganda and the hateful utterances of the perpetrators of Myanmar's genocidal acts as they were committing them reveal Myanmar's genocidal intent. I will also respond to Myanmar's attempts to dismiss this significant evidence. Myanmar did not have much to say last week about the content of the hate speech, propaganda, and hateful utterances that I outlined in my presentation in the first round. The evidence is essentially unchallenged. Instead, it focused on why, in its view, hate speech and propaganda are not indicators of genocidal intent, and why such content cannot be attributed to the state. Myanmar is wrong. I will address Myanmar's arguments by focusing first on the question of genocidal intent, then on the matter of attribution, and finally on the content of the hate speech, propaganda, and utterances by soldiers as evidence of genocidal intent. Counsel for Myanmar argued that there is no direct inference of genocidal intent from hate speech or propaganda, and that such an inference can only be drawn from a pattern of conduct. The Gambia disagrees. While, of course, hate speech may form part of a pattern of conduct, an issue to which I will return in a moment, it may also support a direct inference of genocidal intent. As Professor Sands explained 2 weeks ago, the court in Bosnia clearly stated, and then affirmed in Croatia, that the specific intent must be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly demonstrated to exist. Evidence of a pattern of conduct is one way to show that a general plan exists, but it is not the only way. The Gambia submits that the evidence of Myanmar's anti-Rohingya hate speech and propaganda, especially that which was expressed by Senior General Min Aung Hlaing directly, and that which was disseminated by the Tatmadaw on Facebook, offers convincing evidence of Myanmar's genocidal intent. It demonstrates the existence of a genocidal plan or policy. Counsel for Myanmar notes that in Croatia, the court did not use speech factors in assessing the existence of a pattern of conduct and the inference to be drawn therefrom. This case, however, is different. First, Croatia was essentially a case about territory. Second, the Gambia is not solely arguing for inference of genocidal intent based on a pattern of conduct, which is how Croatia pled its case. The Gambia is arguing that, in addition to a well-established pattern of conduct as found by the UNFFM, particular circumstances in certain villages convincingly show genocidal intent. Alongside this, the Gambia is arguing that anti-Rohingya hate speech and propaganda and the hateful utterances of Myanmar soldiers provide convincing evidence of a genocidal plan or policy. This is outside the framework of a pattern of conduct analysis. Further, in this case, the anti-Rohingya hate speech and propaganda and the hateful utterances of soldiers are also relevant to drawing an inference from Myanmar's pattern of conduct. In Croatia, the court did not say that speech factors are irrelevant to a pattern of conduct analysis. Rather, it identified the factors that it found to be the most important in that case. In this case, the court should find these indicators to be part of the pattern of conduct and important. As detailed in the IIMM hate speech report, the content that the Tatmadaw disseminated on Facebook was done before, during, and after the clearance operations. The speech was intertwined with the clearance operations taking place on the ground. And some of that content disseminated offers direct evidence on how the clearance operations were conducted and how the military incited genocide. Counsel for Myanmar asserted that the Gambia hadn't even attempted to link hate speech to genocidal intent with reference to particular circumstances. This is wrong. As articulated in our first round, the Gambia is arguing that the particular circumstances of the clearance operations, especially in the main villages, convincingly show Myanmar's genocidal intent. In Maung Nu and Chut Phin, there is evidence of hateful utterances by soldiers, offering proof of the specific targeting of the Rohingya. Witness NJ, for example, testified in her witness statement that such hateful language was used by soldiers during their attack on Chut Phin. This is direct evidence. Finally, Myanmar has not contested the ICTR case law cited by the Gambia on hate speech and anti-group propaganda, nor has it contested the ICTY and ICTR case law on utterances of perpetrators as indicators of genocidal intent. I now address the issue of attribution. First, it is uncontested that the speeches of Senior General Min Aung Hlaing and the content disseminated by the Tatmadaw and Myanmar's ministries and embassies are attributable to Myanmar. Second, regarding the Facebook content disseminated surreptitiously by the Tatmadaw, Counsel for Myanmar asserts that the evidence for this is not fully conclusive, citing Myanmar's rejoinder paragraph 1137, the very same paragraph that I displayed for you in my slide number 12 from the first round. With that, Myanmar acknowledged that government employees or members of the Tatmadaw or the police force created fake Facebook accounts, but then suggested without evidence that they acted outside the scope of their employment on their own initiative. There is no evidence for this highly implausible assertion, and what evidence you do have supports the contrary view. Meta, which runs Facebook, investigated and found these accounts were linked to and controlled by the Myanmar military. Nathaniel Gleicher, head of security policy at Meta, testified to this fact in an affidavit. The IIMM investigated and confirmed that accounts taken down by Meta formed an interconnected military network, Myanmar's military network. These findings are corroborated by independent investigative reporting by the New York Times in October 2018. Moreover, Myanmar has tried to reconstitute these networks, and Facebook has taken further accounts and pages down on several occasions to thwart those efforts. The evidence that these accounts were controlled by the Tatmadaw is fully convincing. The content of these accounts, as detailed in the IIMM hate speech report, are directly attributable to Myanmar. Third, the statements of political parties may not be directly attributable to the state, but they clearly show the state's tolerance for genocidal rhetoric. The Rakhine Nationalities Development Party held the majority in the Rakhine State Legislature in 2012 when it called for a genocidal policy. The chair of the Peace and Diversity Party's explicit call for genocidal violence went unpunished. Just a few days ago, in a video posted online with over 500,000 views already, the now former chair of that political party reiterated his call for genocidal violence and said of the Rohingya, quote, "If you don't want to be wiped out, don't come," and quote, "If you come, we will do it," end quote. His party is aligned with the military's Union, Solidarity, and Development Party in the current election. Fourth, Counsel for Myanmar says that the views of Buddhist monks are not attributable to the state. He is wrong. They are attributable because the state endorses and disseminates them, which is the case at least for the content from Sitagu Sayadaw and Ashin Wirathu. Sitagu's sermon absolved a ruler for mass genocidal murder because the 500,000 people killed were deemed to be like animals. That sermon was given to troops in October 2017 and then disseminated by the Tatmadaw on Facebook. The state's official message of absolution for genocidal acts could not be more clear. Myanmar does not deny that the military facilitated Warathu's travel throughout northern Rakhine State after the 2016 clearance operations and before the 2017 operations. That is an overt act of endorsement. Fifth, Myanmar argues that the genocidal intent of individuals like soldiers cannot be attributable to the state. But the state's failure to prevent their genocidal acts is a direct violation of its obligations under Article 1 of the Convention. The genocidal intent of soldiers is also evidence of a state's genocidal plan or policy. Finally, Myanmar argues that the Gambia has not shown that hate speech and propaganda reflect a genocidal intent. The Gambia disagrees. I have already provided historical context from other genocides to show how hate speech and propaganda indicates genocidal intent and led to actual genocide. I focused on messages of dehumanization, accusations in a mirror, and threats to group purity. Those themes are present in Myanmar's anti-Rohingya hate speech and propaganda, as confirmed by the IIMM's hate speech report. Counsel for Myanmar argues that Senior General Min Aung Hlaing's unfinished job speech was taken out of context. The Gambia disagrees. The paragraph about, quote, cooperative efforts and, quote, local people returning home does not refer to the Rohingya. If Myanmar wanted them to return, they could have repatriated them quickly, as they did with witness M1 and other members of her Hindu community. The Rohingya still languish in refugee camps over 8 years later. And we know, through the IIMM's report on this issue, that Myanmar was actually engaged in a demographic replacement effort to bring more Buddhists into northern Rakhine State. Other content in that speech confirms that the Gambia's interpretation of it, which is consistent with the UN FFM's interpretation, is correct. In that very same speech, General Hlaing said of the Rohingya, quote, "We openly declare that absolutely our country has no Rohingya race." Furthermore, in that speech, the so-called 1942 Alithankya crisis was mentioned 3 times. I will show you 2 of them. Quote, Rakhine ethnics lost their land in the Alithankya crisis that broke out in Rakhine State in 1942, in which Bengalis attacked, murdered, and coerced them into leaving their homes. We will never let such a terrible occurrence happen again. Quote, during the Alithankya crisis in 1942, over 20,000 ethnic Rakhine people were slaughtered. Bengalis, after murdering ethnic Rakhine people, seized their land and villages and lived there. End quote. The message is clear. The Rohingya pose a genocidal threat and must be dealt with. That is the unfinished job he was referring to, one that has lingered since 1942. As I mentioned in the first round, other Tatmadaw messaging on Facebook repeated their incendiary references to 1942. Myanmar argues that General Hlaing's speech of 20 September 2017 is also taken out of context, and that General Hlaing was talking about immigration matters. In that same speech, he said, quote, "This area was a British colony over 100 years ago. We are facing the consequences of their reckless acts till now. At that time, Bengalis from Bengal region were conveyed into the country without any restrictions. Later, the Bengali population exploded and the aliens tried to seize the land of local ethnics. The 1942 Alithankya crisis is the worst in history." End quote. when General Lang later in his speech states that, quote, race cannot be swallowed by the ground but only by another race, he is clearly referring to the Rohingya. There is a sentence right before the passage that Professor Talman showed in his speech, wherein General Lang said, quote, collective efforts must be made to protect the minorities of Buthadong/Mong Tao region, such as Mro, Kami, Tet, and Dainet. By excluding the Rohingya from those who need protection, it is obvious that he is inciting those other groups against the Rohingya, who otherwise would swallow them up. Myanmar passes without comment on the other speech of General Lang from December 2017. He said that the, quote, Tatmadaw must fully protect the ethnic minorities in Rakhine region not to have the genocide, end quote. Yet another example of accusations in a mirror. Myanmar further states that there is a difference between hate speech and incitement. We agree. Ms. Jones covered that matter in the first round when addressing other breaches of the convention. I do not need to repeat the distinction that she drew. Regarding the post disseminated by the Tatmadaw in July and again in December 2017 entitled, Why Did Hitler Kill the Jews?, Professor Talman says that the Rohingya and Muslims are not mentioned in this post. But he does not explain why it was posted or challenge my explanation that the message implicitly draws a parallel between the false Nazi propaganda of the 1939 Danzig massacres and the 1942 Alethankia crisis that General Lang consistently refers to. Finally, regarding the utterances of soldiers, Myanmar points out that the Reuters hate book article does not indicate that those messages are from soldiers. I take the point. But Myanmar has not addressed the other evidence of hateful utterances by soldiers, including those listed in slide 27 of my first round presentation on this topic. The UN FFM has reported on such utterances in many contexts, including during perpetration of sexual violence. Myanmar also passes in silence on the testimony of witness P5513, who indicated that the Tatmadaw soldiers' views of the Rohingya were shaped by the military's propaganda. So too does it pass in silence on the many fabrications and other forms of anti-Rohingya propaganda disseminated by the Tatmadaw and taught to its soldiers, who ended up committing the genocidal acts. Those were cited in footnote at pages 50 to 51 of the transcript for the afternoon session of 12 January. In conclusion, the Gambia submits that Myanmar's anti-Rohingya hate speech and propaganda and the hateful utterances of Myanmar soldiers during the clearance operations are powerful indicators of genocidal intent, both of Myanmar's leadership and of its soldiers committing the acts of genocide. Thank you, Mr. President, members of the court, for your kind attention. Mr. President, I kindly request that you call Ms. Ho to the podium.
I thank Mr. Suleiman for his statement. I now invite Ms. Tien Phuan Ho to address the court. You have the floor, madam.
Mr. President, distinguished members of the court, this part of the Gambia submissions returns to the clearance operations. I will respond to Myanmar's arguments on the three villages of Minji, Chutben, and Maungnu. Mr. Lowenstein will then address Myanmar's arguments in respect of the Tatmadaw's pattern of conduct in northern Rakhine State. Since we last addressed you, you have heard from the Gambia's three witnesses, each from one of the three villages. They have told you what they personally went through and saw. Their every word corroborates the determinations of the UN fact-finding mission report and other independent reports. What is Myanmar's answer? To say that these facts are not established and to invoke, yet again, counterterrorism. Nothing in what Myanmar presented last week can challenge the Gambia's evidence in respect of the unspeakable atrocities in Minji, Chutpin, and Mangnu. Not its familiar nitpicking exercise, and certainly not its refrain of counterterrorism. Starting with Minji, or Tula Toli and Rohingya, Myanmar claims that none of the facts presented by the Gambia are established. The court will recall that these facts are derived from the determinations of the UN fact-finding mission, corroborated by independent reports from Amnesty International, the Holocaust Memorial Museum, Human Rights Watch, independent journalists, 3 witness statements from the IIMM, and 21 signed witness statements from Legal Action Worldwide. Myanmar has put no evidence before the court to refute those facts. Instead, it has leveled 2 challenges against the Gambia's evidence in Minji. First, it says, not a single word is said about ASA by any of the Gambia's witnesses, and therefore these witnesses are unreliable. Second, many of the Gambia's witness statements are anonymous and therefore without probative weight. Myanmar is wrong on both counts. The court will recall the harrowing account of witness MS from Minji. He gave a statement to Legal Action Worldwide in 2020 from which his name and identifying information were redacted. And it does not mention ASA. Yet Myanmar did not and could not challenge his testimony last week. Its criticism of anonymization, untested and unreliable evidence collapsed in the face of the evidence he gave before you in person. Not just because of what Myanmar admitted was an atrocity that he lived through, but also because his account aligns in every detail with the determinations of the UN fact-finding mission and other independent evidence, as well as the testimony of other Rohingya witnesses just like him. He described military everywhere surrounding the village from all sides, and the other side was only river. He described children being thrown into fires or into the river. He also told you that women were separated from the men, taken to houses, which was then set on fire. They included his wife and children, whom he never saw again. He further told you that his daughter was shot while attempting to escape across the river. Witness MS lost 6 members of his immediate family and 50 more of his extended family. Witness MS is only one of the 21 witnesses who provided a signed statement to Legal Action Worldwide. Those witnesses, too, described the modus operandi of the Tatmadaw in Minji. Surrounding villagers, indiscriminate shooting, systematically executing men and boys, massacring children, raping and gang-raping women, and burning everything to the ground. If the court considers the testimony of witness MS to be compelling and gives it substantial weight, it should do the same for the remaining 20 witnesses from law whose statements were given in the same way. Myanmar asserts that the lack of contemporaneous mention of ASA by these survivors and witnesses, including witness MS, is, quote, contrived and intended to mislead and to deceive. Mr. President, did witness MS appear deceitful or misleading to you? Or can his account be somehow explained or justified by the presence of ASA in Minji? The answer is no. The Gambia has also put on the record 3 IIMM witness statements from Minji. Those statements mention ASA, and they also corroborate the modus operandi employed by the Tatmadaw in Minji. For example, witness 1477 recalled, quote, villagers fleeing towards the riverbank and military soldiers were pursuing them and shooting at them. Males raised their arms above their heads to surrender, but the military came close to them and shot them immediately. And all the houses where the military took the women set on fire. Witness P1301 recounted, "I witnessed children who were scattered everywhere, being killed with knives and machetes, and snatched from their mothers and thrown into the fires." End quote. Myanmar claims an IIMM witness, quote, had lied in his earlier law statement about his knowledge and fear of ARSA, yet his later IIMM statement is fully consistent with his earlier statement in respect of the Tatmada's modus operandi in Minji. Survivors focus on the atrocities that they observed. That is natural, and Myanmar's attempt to draw adverse inference from their silence on ARSA is frankly irrelevant. Myanmar devoted much time to a description of alleged ARSA activities in and around Minji. Around more than in, perhaps, because its claims of, quote, heavy ARSA presence pointed to a place 10 kilometers from Minji. The presence of ARSA there and in other villages, none of which were Minji, in the days and weeks prior to 8 a.m. on the 30th of August 2017, does not somehow render the Tatmada's attack on Minji responsive. The UN fact-finding mission identified just 2 ARSA attacks in other villages in the vicinity of Minji, but these were several days earlier. And in response, the Tatmada had already conducted 2 separate clearance operations. The mission recorded no armed engagement with ARSA on the day of the clearance operations in Minji. Myanmar says otherwise, claiming that there were repeated clashes with groups of hundreds of Bengalis in Minji. What is the evidence to support this? Myanmar only has its own military operational reports and statements from its own military officers. Professor Newton told you that military reporting of this kind is inherently unreliable and has no probative value unless it is corroborated by independent external examinations. Myanmar has no independent corroboration here. Mr. President, members of the court, I now turn to Chutpin, or as the Rohingya know it, Shop Parang. Myanmar again says that the evidence, the facts presented by the Gambia are not established, despite being grounded in the UN fact-finding mission's report, independent reports from Amnesty International, Physicians for Human Rights, Fortified Rights, the International State Crime Initiative, as well as more than 20 witness accounts from law and 4 signed witness statements from the IIMM. Again, Myanmar has offered no evidence to contradict these facts. Myanmar resorts to its usual attack on the so-called contrived silence on ARSA in the law witness accounts, as well as their anonymization. One such witness account is that of witness NJ, from whom the court heard directly last Wednesday. Such a witness, every detail of her testimony corroborates the determinations of the UN fact-finding mission and other evidence from Chutpin in respect of the modus operandi employed by the Tatmada in Chutpin. She told you that the military tortured and took away her husband and father-in-law, whom she never saw again. She told you that a soldier grabbed her infant son from her arms, stabbed him with a knife, and threw him into a fire. She told you she was gang raped. She told you she felt they wanted to destroy as a whole the Rohingya community. She also told you that the military burned the whole village. Witness NJ is one of more than 20 witnesses from Chutpin whose experience was captured in a summarized account by law, which Myanmar criticized as unsigned, anonymous, and should be given no probative weight. You have heard her live testimony. It showed that the law's interview note with her preserved the substance and detail of the underlying evidence. The court, therefore, can rely on those interview notes. Myanmar asked witness NJ during cross-examination about ARSA. She said, quote, she had no idea about any of these names and therefore didn't talk about them. Was there anything deceitful about witness NJ, a mother who never left her village, who spent her days caring for her children, to not know about ARSA? You heard her say her fear was not ARSA, but the reach of the Myanmar government. Quote, Bangladesh camps are very close to the Myanmar border, so I had the fear that the government might reach and come and kill my family members." End quote. Counsel for Myanmar surprisingly claims that the Gambia, quote, avoids the IIMM witness statements from Chutpin because it, quote, reveals a quite different picture of the military's conduct, even while acknowledging that the Gambia submitted 4 IIMM witness statements for Chutpin. Mr. President, in reality, the picture is not that different. Every IIMM statement in evidence, including the 2 introduced by Myanmar, describe the same modus operandi employed by the Tatmadaw and Chutpin, as documented by the UN fact-finding mission and other independent investigations. Mr. Reichler took you to these statements earlier, but he has not read you this passage from witness P135, the witness that Myanmar trumpeted for saying that military do not attack ladies and let people go to Bangladesh. Quote, "I saw a lady whose breast was cut and who died instantly. I saw that she was taken by the militaries. When she tried to resist, I saw that a man came, held one of her breasts and chopped it off. She started bleeding a lot and screaming, and the militaries shot her from a distance." Hardly an account that exonerates the Tatmadaw. In a now familiar pattern, Myanmar turns to counterterrorism as its mantra for justifying the atrocities in Chutpin. What Myanmar never explains is why the events it relies on, occurring in locations some 10 kilometers from Chutpin or otherwise outside of the village, could provide justification for what happened in Chutpin itself. The only incident that Myanmar locates in Chutpin is the attack on the Chutpin police by, quote, a member of ARSA from Chutpin Bengali village with homemade bombs. The fact-finding mission was unable to verify this attack. Myanmar's answer is simply, trust our own military operational reports, our own military witnesses, and statements from detainees in our own custody. You heard from Professor Newton about the reliability of such evidence. Absolutely unreliable and has no evidentiary weight. Even if it is assumed that the attack on Chutpin police by ARSA did occur, Myanmar has no answer to the conclusion of the UN fact-finding mission that plans for a clearance operation in Chutpin appear to have been made prior to this incident, nor for the way in which it was conducted, a modus operandi that speaks not of counterterrorism, but of genocide. Mr. President, I finally address the village of Mangnu or Monopara in Rohingya. As with the other 2 villages, Myanmar has produced no evidence to contradict the determinations of the UN fact-finding mission, corroborated by multiple sources, including Amnesty International, the International State Crime Initiative, the United States Holocaust Memorial, signed witness statements from the IIMM, Fortified Rights and Law. Counsel for Myanmar simply says these facts are not established, complaining once more about the Gambia's reliance on, quote, anonymous summary hearsay notes. Yet you have heard from witness MN, who was once such an anonymous witness. He stood before you and described how soldiers opened fire in Mangnu and separated him from his wife and children at gunpoint. He recounted being rounded up with other men and having his hands tied. He told you how soldiers kicked him in the back and neck, forcing him to lie face down on the ground. From there, he heard the voices of other men crying out to God. Then came the gunshots. Witness MN then recounted the scene that haunts him to this day. Piles of bodies, more than 60 men and boys, stacked together in death. Among them lay his elderly father and his 8-year-old nephew. In answering Judge Vladi's question on whether any of the 87 men with whom he was captured survived, he said, none of them. That testimony is consistent with the fact-finding mission's indication that, quote, up to 100 people, mostly men and boys, were executed in Mangnu. Professor Newton told you the modus operandi of segregating and executing men and boys reminded him of Srebrenica. None of this testimony has been challenged or disproven by Myanmar's counsel. Equally false is Myanmar's assertion that the IIMM witness statements concerning Mang Nu contradict the Gambia's evidence. On the contrary, they confirm it. For instance, the statement by witness P1493, introduced by Myanmar, recounts how, quote, the ground was wet with blood in Zahid Hussein's compound. The witness describes seeing the dead body of a child aged about 2 years old, with one part of his head missing. A different statement, also introduced by Myanmar, describes the killing of another boy, adolescent, maybe between 14 and 16, who was shot in the head by a soldier that half of his head and brains were blown out. Last week, Myanmar argued for the first time that the clearance operation in Mang Nu was a targeted strike on, quote, ARSA cell leader Zahid Hussein and his home address. That, of course, is a significant claim. Myanmar's single source of evidence is a statement from the IIMM, the very body whose materials Myanmar dismisses elsewhere as having no evidentiary weight. Be that as it may, Myanmar's new argument changes nothing. The evidence plainly shows that the clearance operation in Mang Nu was not targeted. If the objective was to eliminate an ARSA leader and his affiliates, one would expect the operation to end with arrest and detention of select individuals and with the separation and protection of civilian population. What transpired instead was an indiscriminate mass execution, including of children and the elderly. Myanmar Council asserts that ARSA militants began to assemble in Mang Nu itself throughout the 26th of August, but it offers no citation in support. It is not disputed that there was no documented ARSA attack in Mang Nu on the 27th of August before the security forces arrived. What prompted the Tatmadaw to descend upon Mang Nu was not an attack on the village itself, but an uncorroborated suspicion that ARSA members from nearby village Hapong Tho Pen could be hiding around Mang Nu. In its opening presentation, Myanmar alleged additional ARSA activities in the surrounds of Mang Nu. It is telling that just as with Minji and Chutpin, Myanmar must resort to peripheral events taking place somewhere at some distance to justify what transpired in Mang Nu. In reality, the Tatmadaw's arrival in Mang Nu was not related to any ARSA attack. It was part of a rolling wave of clearance operations across Rohingya villages. The Tatmadaw terrorized one Rohingya village, driving its residents to flee to another village. It then used that displacement as a pretext to launch additional clearance operations in those surrounding locations on the ostensible basis that fleeing civilians included ARSA terrorists. This self-generating logic, attack, displace, and attack again, reveals the true nature of the operation, not to neutralize any security threat, but to destroy an entire community. Mr. President, members of the court, I conclude by responding to 6 points raised by Myanmar's counsel in its opening presentation on the 3 villages. First, Myanmar claims that the use of force by Myanmar Defense Services was directly responsive to ARSA-led violence in northern Rakhine State. As we have demonstrated, Myanmar has offered nothing but its military documents to prove this in respect of the clearance operations in Minji, Chutpin, and Mang Nu. Counsel for Myanmar asks, rather ironically, and I quote, "One wonders how then the Gambia envisages any state might defend itself in proceedings such as these if it could not rely on such self-serving and unreliable evidence." Professor Newton already answered this. Corroborate your military reports with independent and external examinations. Even if we were to accept Myanmar's clearance operation in the 3 villages was somehow responsive to ARSA attacks, what was its response? a modus operandi of encircling villages, indiscriminate shooting, segregating and executing men and boys, massacring children, raping and gang raping women and girls, comprehensive burning of Rohingya settlements while leaving the nearby Rakhine areas intact. This, as Professor Newton has now testified, cannot simply be described as disproportionate uses of force by the Tatmadaw. It was part of an extermination campaign to destroy the Rohingya group. Second, Myanmar trumpets its rules of engagement, which it claims were distributed to security services before the clearance operations. But as Professor Newton observed, and I quote, "The Tatmadaw published rules of engagement. They disseminated them to troops. Then, with respect to this portion of the population, they engaged in that sustained modus operandi from start to finish, which not only was not compliant with those rules of engagement on an aberrational basis, it simply ignored that they existed." End quote. Third, as Mr. Reichler demonstrated, the Gambia evidence in respect of the clearance operations, including in the 3 main villages, is independent, reliable, and compelling. The 3 witnesses who spoke before the court last week confirmed this beyond any doubt. Fourth, Myanmar attacks the Gambia's fatality figures in the 3 villages because they, quote, "do not accurately reflect the evidence." While the figures the Gambia put forward are necessarily estimates, they represent the best available numbers in light of the nature of the clearance operations, during which the fact-finding mission found that people were killed without witnesses. Their bodies were subsequently and systematically disposed of. Finally, Myanmar is wrong to claim that the events in Minji, Chitpin, and Maungnu were not typical of events during the clearance operations in northern Rakhine State. The UN fact-finding mission found the same modus operandi in a total of 54 separate locations, with evidence extending to at least 20 more. Mr. Lowenstein will address you on that next. Mr. President, members of the court, I thank you for your kind attention. May I ask that you call Mr. Lowenstein to the podium?
I thank Ms. Ho. The court will observe a break here of 15 minutes before the court gives the floor to Mr. Lowenstein. And so the sitting is suspended.
La Cour.
Please be seated. The sitting is resumed. I now give the floor to Mr. Andrew Lowenstein. You have the floor, sir.
Mr. President, members of the court, good afternoon. I will respond to Myanmar's attempt to challenge the determination by the UN fact-finding mission, corroborated by many others, that Myanmar exhibited a pattern of conduct that can only be understood to reflect its intention to destroy the Rohingya as a group in northern Rakhine State. In so doing, I will take stock of the evidence and arguments, including the witness evidence, that go to the question of Myanmar's pattern of conduct. I begin with the requirements. As the court held in Croatia v. Serbia, a pattern of conduct simply requires a consistent series of acts carried out over a specific period of time. A pattern of conduct can thus be established, for instance, where widespread attacks are carried out according to a generally similar modus operandi. In the Croatia case, such a pattern was found to exist because there is evidence that widespread attacks by the JNA and Serb forces on localities with Croat populations in various parts of Croatia were carried out according to a generally similar modus operandi. Myanmar has sought to argue that establishing a pattern of conduct requires the court to engage in a minute examination of every instance where Myanmar is alleged to have committed an act that forms part of the general pattern, and that in each place, precisely the same order and types of events need to be established. You heard this during Ms. Lowry's presentation, in which she went village by village, which tried to call into question the evidence obtained by the fact-finding mission and others in regards to those villages. Mr. Reichler has already shown why the evidence is reliable, credible, and trustworthy. But Myanmar's approach is misconceived for an even more fundamental reason. As the court explained in the Bosnia case, it need only consider the facts alleged in the light of the question whether there is persuasive and consistent evidence for a pattern of atrocities which would constitute evidence of dolus specialis. And for this purpose, it is not necessary to examine every single incident reported by the applicant, nor is it necessary to make an exhaustive list of the allegations. In other words, no Myanmar-style audit is needed. Instead, it is sufficient for the court to examine those facts that would illuminate the question of intent or illustrate the claim by the applicant of a pattern of acts committed against members of the group, such as to lead to an inference from such pattern of the existence of a specific intent. Myanmar's attempt to suggest that any variation somehow negates the pattern is equally flawed. It does not square with the court's jurisprudence that a generally similar modus operandi is sufficient. The court's approach is plainly correct, and Myanmar presents no cogent reason to depart from it. Inevitably, there will be locations where the available evidence may show greater or lesser levels of killings, sexual violence, or other forms of abuse. All the more so in circumstances where, as is the case here, the available evidence has been affected by efforts to destroy the evidence, and independent investigators are refused access. And of course, inevitably, there will be variation over time and location and how the perpetrators conducted themselves. A pattern of conduct does not require undeviating, identical conduct in all locations and at all times. It simply requires sufficient similarity in the perpetrator's modus operandi to show a broadly common and consistent approach across place and time. Here, there is certainly broad commonality. The totality of the evidence, including Professor Newton's unchallenged expert testimony, corroborates the mission's finding, confirming that the evidence is consistent in showing that Myanmar carried out widespread attacks according to a generally similar modus operandi, and that this modus operandi includes persuasive and consistent evidence for a pattern of atrocities. Specifically, the mission verified the common modus operandi of the clearance operations to exist with respect to at least 54 villages and received first-hand accounts of an additional clearance operations conducted in a further 22 locations. It is to the particularities of that pattern to which I turn now. I begin with Myanmar's preparatory actions. As the first round made clear, much of the evidence is undisputed. Myanmar concedes it deployed Tatmadaw units to northern Rakhine State prior to the wave of clearance operations that began on the 25th of August, 2017. Ms. Lowry said so expressly. Those deployments included highly trained units, including the 33rd and 99th Light Infantry Divisions, or LIDs, which Myanmar airlifted to northern Rakhine State upon the command of the Army's Commander-in-Chief, which soon thereafter carried out many of the clearance operations. Nor does Myanmar challenge the fact that the Tatmadaw deployed its units to strategic locations in close proximity to Rohingya villages. These are all significant, undisputed facts. The underlying facts with respect to Myanmar's other preparatory acts are likewise conceded. In the first round, Myanmar accepted that it had ordered the removal of fences in Rohingya villages, confiscated the Rohingyas' sharp implements and agricultural tools, and imposed draconian curfews and restrictions on movement. The most Myanmar could do was to try to suggest these were anti-terrorism measures that were not directed at the Rohingya as a group, but applied in a non-discriminatory manner, a point unsupported by and in fact directly contradicted by the evidence before the court. Again, Professor Newton's testimony is instructive. As he explained, bona fide anti-terrorism measures would be selectively targeted against suspected terrorists. They would not be imposed indiscriminately against the group as a whole. With respect to Myanmar's termination of humanitarian assistance in the weeks prior to and at the height of both the 2016 and 2017 clearance operations, Myanmar did not dispute any of the relevant facts. Not its refusal to allow the World Food Program to distribute aid, not its termination of other food assistance programs, not the fact that these actions occurred against the backdrop of the World Food Program's warning that much of the Rohingya population faced imminent starvation, not Myanmar's refusal to allow healthcare organizations to continue providing urgently needed assistance. Ms. Lowry could not even bring herself to claim these were anti-terrorism measures. All we heard was unsupported hand-waving about security. But the aid organizations themselves had no concerns about a lack of security preventing their operation, a fact confirmed by Mr. Riley's witness statement. Mr. President, the reality is that the clearance operations were pre-planned. The steps taken to weaken the Rohingya population and put in place Tatmadaw units to attack them on command form part of a consistent pattern across northern Rakhine State. Crucially, the evidence also establishes that when Myanmar launched the clearance operations, their modus operandi involved the indiscriminate targeting of the entire Rohingya population. Despite overwhelming evidence to the contrary, Myanmar nonetheless still insists, with the sole exception of the massacre at Indin, for which there is irrefutable photo documentation, the Tatmadaw engaged in no extrajudicial killings. As Ms. Lowry reported, in relation to the alleged killing of males, save for, in her words, the incident at Indin, Myanmar denies that soldiers engaged in extrajudicial killings. We will see if Myanmar maintains that position in view of Mr. Hooper's acknowledgement of the atrocity at Mingi. Last week, Myanmar tried to suggest that the Gambia lacks evidence for the indiscriminate killing of Rohingya civilians during the 2016 wave. Not true. The OHCHR, discussed by Mr. Reichler, concluded that the security forces deliberately targeted the entire Rohingya population in the area. Those are the words of the report. This fully aligns with the FFM's own conclusion, namely that the 2016 operations were characterized by torture, rape, and sexual assault, killings, and the destruction of homes and mosques. These, the mission found, involved the same tactics and violations that were later seen in 2017. And it accords with the findings of the very Amnesty International report upon which Myanmar places reliance. It reported eyewitnesses who recounted how in 2016, military personnel attacked Rohingya villagers at random, leading to deaths and injuries, and how soldiers entered their village and fired randomly at men, women, and children, often while they were fleeing in fear. Myanmar's employment of the same modus operandi during the second wave is fully documented, not least by the fact-finding mission and the 3 witnesses who testified last week. Multiple witnesses also reported that the military was shooting madly on everyone they saw and in every direction. The modus operandi included killing civilians while fleeing. The evidence is clear. It happened to witness MS's daughter, just as it happened to the daughter of a survivor from Chien Chong, who recalled that as people were running, they were shooting at them. That is how my daughter died. She was hit fleeing. Medical reports referred to by the fact-finding mission confirm, and I quote, that many patients, including women, children, and the elderly, had bullet entry points from behind, consistent with being shot while fleeing. The record includes examples from many places. Significantly, the shooting of Rohingya refugees who were fleeing was common across different Tatmadaw units, including the 33rd and 99th LIDs that were moved to Rakhine State in the weeks leading to the clearance operations. This happened at Mingi, where the clearance operation was carried out by the 99th. The FMM reported that soldiers opened fire directly at a large number of people fleeing towards the shore. Many were shot. One man reported, I think that everybody from my village was running towards the shore. While I was running, there was a lot of shooting, and I saw many people hit and falling down. And the 99th did so as well at Kyok Pandu. There, the mission determined that it carried out a clearance operation.
Mr. Lowenstein, please slow down a bit. The interpreters are having a problem.
There, the mission determined that it carried out a clearance operation in which fleeing people were shot, injured, or killed. A different unit, the 33rd LID, engaged in a similar pattern of behavior in Chep Pin. The FFM reported that the soldiers conducting the operation there opened fire, shooting at villagers, including those who were fleeing. Much the same occurred in Ko Tang Kok, where the mission found that the 33rd led the operation, shooting into the village and towards people fleeing. This brings me to sexual violence, another part of the modus operandi. Myanmar does not appear to contest that a pattern of sexual violence is indicative of genocidal intent. It expressly accepted that sexual violence can never form part of a legitimate counterterrorism operation. Its only response was to question whether the evidence of sexual violence is sufficient. In that connection, Myanmar sought to argue last week that, as Mr. Blom Cooper put it, the allegations of sexual violence arise predominantly in just 2 villages, Mingi and Chep Pin, and that, in his words, there is no reliable evidence of their widespread character. Mr. Blom Cooper appeared to take umbrage at even the suggestion that the Tatmadaw could have committed sexual violence. Taking on the role of Tatmadaw character witness, he assured you that even isolated incidents of sexual violence would, in his words, run counter to the ethos of the Myanmar Defense Services. That's not even argument. That's just propaganda. I turn now to Judge Charlesworth's question, which asked, is the Gambia able to identify the locations where what it calls the hundreds of instances of sexual violence are alleged to have occurred? In answering, I make clear, as the question recognizes, that there are hundreds of instances of sexual violence, not that they necessarily took place in hundreds of locations. But they certainly occurred in a great many locations, far more than the 2 that Myanmar accepts. Professor Sand's reference to sexual violence as being widespread is a direct quote from the fact-finding mission. The locations of many instances of mass sexual violence can be pinpointed, but we do not claim to have a comprehensive list. So we say, on the basis of the FFM evidence, that sexual violence, including gang rape and sexual mutilation, took place in at least 10 village tracts across the 3 townships of northern Rakhine State during the 2017 clearance operations alone. These 10 separate places were Ka Mong Sek, Mingi, Kien Chong, Kyok Pandu, Badakar, Nyat Nyat Chong, Tong Bazar, Chinthamar, Gudarping, Mongi Tong, and Chup Pin. The FFM also noted that alongside these 10 primary locations where this pattern of conduct undoubtedly occurred, the mission received further credible reports of mass gang rapes in a number of other locations. Some of these other locations are mentioned in Chapter 9 of our memorial and Section 3A of Chapter 7 of our reply. The widespread nature of this pattern is confirmed by the U.S. State Department survey that Mr. Reichler described this morning. No fewer than 45% of the more than 1,000 randomly interviewed respondents have personally witnessed rape or evidence of rape. Indeed, the survey showed that the military and police did not appear to hide the rapes from their peers or from those above them in their chain of command. Rather, rapes were largely public in nature, with many assaults either taking place in public view or with perpetrators leaving evidence of such assaults, including the victims' corpses, which clearly portrayed marks of rape in public view. Such evidence of sexual violence perpetrated in full view of superior officers is compelling evidence that it was part of a modus operandi. Moreover, as the State Department's chart on your screens indicates, such levels of sexual violence occurred throughout northern Rakhine State. Although the precise numbers are unknowable, we know that there was at least hundreds of victims. The FFM cites a figure of 1,834. Médecins Sans Frontières reported having treated 230. That's just one aid organization. That does not include those who received treatment from other organizations. It does not include those who received no treatment at all. And it does not include the women and girls who the Tatmadaw killed or who succumbed to injuries while making their way to Bangladesh. The Physicians for Human Rights survey that Mr. Reichler mentioned noted that healthcare providers reported higher numbers of pregnant women during months that corresponded to the patients having conceived in and around August 2017. In the words of one physician, 9 months after August 2017, there was a huge increase in the birth rate. The implications are obvious. I turn now to another part of the modus operandi, the intentional killing of children. I addressed its legal significance in the first round. Myanmar left it unrebutted. Instead, Myanmar's response was limited to Ms. Lowry's statement that the reference to children in the counter memorial reflected the fact that, as she put it, Rohingya youths included those who in most societies would be counted as children, but are nonetheless found in the rank and file of those confronting the military, thereby putting themselves in the way of harm, and, she said, were indistinguishable from older persons. Mr. President, in the first round, I observed that Médecins Sans Frontières estimates between 734 and 2,109 children under the age of 5 died during the clearance operations or were killed during the flight to Bangladesh. Myanmar made no attempt to challenge those statistics. Not a single one of those deaths can be said to reflect an adolescent who chose to put him or herself in harm's way. Nor can the testimony of the witnesses you heard last week, and then describe the death of his 8-year-old nephew, NJ, the murder of her 2-year-old son, MS, the slaughter of 5 of his children. They were 14, 11, 9, 7, and 3. These murders of children, of innocents, not those lining up to fight government forces, were conducted by separate units of the Tatmadaw, specifically the 33rd Lid in Chop Pien, the 99th Lid in Mingi, and the 564th Light Infantry Battalion in Mang Nu. The reality, Mr. President, is that the record is full of reliable evidence that the killing of young children, including toddlers, infants, even the unborn, formed part of the Tatmadaw's modus operandi in both waves of clearance operations. In that connection, I underscore that the evidence from 2016 is consistent with that from 2017. In other words, they both followed the same modus operandi. That's not surprising. They were closely connected episodes in a broader genocidal program in which the killing of children was central. The PILPG survey included dozens of respondents who recounted brutal attacks against children, including the abduction and disappearances of children, the execution of dozens of children in a single attack, and children being stabbed, slaughtered, dismembered, and beheaded. Respondents recounted babies being smashed against floors and walls, thrown out of windows, thrown into fires, thrown into rivers, thrown up into the air and caught on a sword, or thrown into wells. Many witness statements include accounts of the intentional killing of young children, and many such accounts were obtained by the FFM. To cite but a very few examples, a survivor from Kiep Yo Pien described to the mission seeing the Tatmadaw kill 2 young children who were searching for their mother. The older of the 2, a 6-year-old boy, had his throat cut. The younger, just 4 years old, was stamped to death before the body was thrown into a nearby burning house. Similarly, a 14-year-old boy told the mission how, in Kiok Pandu, he witnessed the Tatmadaw push 10 Rohingya, mainly children, into a house and set it on fire. He believes everyone was killed. The boy recounted one of the children was stabbed when the group tried to leave the house. As you heard last week, Professor Newton has no doubt that each of these features of the clearance operations, the targeting of civilians, including those fleeing, the sexual violence, and the killing of children, was part of the Tatmadaw's modus operandi. None is remotely reconcilable with counterterrorism. Mr. President, this brings me to the next part of the modus operandi, the systematic destruction, often through building, of Rohingya villages. The numbers are effectively undisputed. As I noted during the first round, UNISAT determined that as of the 18th of October 2018, at least 178 Rohingya villages had been totally destroyed by fire, with an additional 214 partially destroyed. Did Myanmar present expert testimony showing that UNISAT was wrong? No, although Mr. Blom-Cooper did opine that he might have identified a few structures that he thinks may have survived. Myanmar also tries to argue that the destruction of these villages somehow doesn't count. Why? Because some destruction may have occurred after the 5th of September 2017, when Myanmar claims to have ceased carrying out anti-terrorism operations. But the truth is, Myanmar did not stop then. Here's what the FFM had to say about the matter. While the government has claimed that clearance operations had ended on the 5th of September, in fact, military engagement continued well into October. This included its efforts to systematically and comprehensively destroy huge swaths of Rohingya villages, as the IIMM documented in its September 2025 report. I reviewed that report with you in detail in the first round. Myanmar had next to nothing to say in response. The most it could muster was to seek to cast doubt as to who was responsible for the program of burning. But the answer is clear and provided in the IIMM report itself, as Mr. Reichler showed you this morning. So too is it found in the December 2017 International Crisis Group report that Mr. Reichler also discussed. Let's be perfectly clear about what the wholesale burning of hundreds of Rohingya villages meant for the Rohingya who had lived in those villages. It was described by the FFM in the following terms. The clearance operations forced hundreds of thousands of Rohingya to flee and walk for days, even weeks, through forests and over mountains to reach Bangladesh. On this journey, many more died or were killed or injured. There was minimum shelter, with people having to sleep in the open with little food or water. This directly impacted Rohingya mortality. The mission determined the appalling conditions of the journey contributed to the high number of casualties. Hundreds of thousands of Rohingya fled with little or no notice and few, if any, possessions. Many had sustained injuries and needed urgent medical care. Mr. President, those appalling conditions are vividly described in the witness statement of Alex Crawford and Neville Lazarus, television journalists with Sky News, who managed to visit Northern Rakhine State in November 2017. You can find it at Annex 374 of the memorial. The video they made of their visit, cited in their statement, can be watched through the link included in the footnote in the compte rendu. The Rohingya facing such conditions had no illusions that they had any prospect of receiving assistance from the same Tatmadaw who had committed horrific atrocities against them. The FFM found that continuing clearance operations and the presence of large numbers of Tatmadaw soldiers and other security forces made it dangerous to travel on main roads or seek shelter or provisions in other villages. Instead, villagers walked for days or weeks in forest and mountain areas, sleeping in makeshift shelters or in the open during heavy monsoon rains and without sufficient food or water. These dire conditions, the mission found, disproportionately affected the most vulnerable, including children and the elderly. Many persons died and were buried in makeshift graves. Here is how one woman described the situation, an account the mission concluded was typical of many. It took 9 days to reach Bangladesh. On the way, I saw 4 or 5 decapitated heads by the side of the road. One of our group died on the journey, a small boy. One woman gave birth. I had a packet of biscuits with me, but nothing else. It was raining heavily. Everything was burning around us. Mr. President, the Tatmadaw's modus operandi included the specific targeting of Rohingya attempting to traverse this hellscape. The scale is indicated by data collected by Médecins Sans Frontières, indicating that fully 13.4% of violent deaths occurred during the period between displacement from their village and arrival in Bangladesh. To be clear, these were not killings that occurred in the context of village-specific clearance operations. Instead, the FFM determined that Tatmadaw soldiers shot at groups of Rohingya who were en route. This included attacks in villages that had already been burned, where fleeing Rohingya were seeking refuge on their journey, as well as attacks in forested areas or when Rohingya were forced into the open, for example, when crossing rivers. The mission's report is replete with evidence that confirms the ever-present danger that Rohingya faced from the Tatmadaw. A woman from Buthodong Township described to the mission how, after walking for 2 days, she and her group were near a river crossing when soldiers opened fire at people as they were crossing. She saw 2 people shot. Another survivor recounted how he and his family were awaiting a boat to carry them across the river when a group of soldiers and police opened fire at a boat carrying people across, killing 4 of the passengers. And here is what still another survivor told the mission. My grandson, who was 3 years old, died when my daughter-in-law jumped into a river while crossing the canal. The military started shooting at people who were about to cross the river. She was afraid and jumped into the river with her son. The child drowned and we found his body later on. Mr. President, I take this opportunity to present the Gambia's observations in regard to Judge Charlesworth's question that asked Myanmar for his views regarding who is responsible for the 178 Rohingya villages that had been totally destroyed by fire by the 18th of October 2017, and the additional villages that had been partially destroyed by that date, including whether Myanmar considers those villages to have been destroyed by ARSA, and if so, the evidence supporting that contention. In considering Myanmar's forthcoming answer, the Gambia respectfully suggests that the court take into account the witness statement of Jonathan Head, the BBC's Southeast Asia correspondent. As recounted in his witness statement, he was present in Northern Rakhine State in September 2017. Mr. Head provides a detailed account of Myanmar's efforts to falsely portray the Rohingya as having burned their own homes. This was done through the staging of photographs and the enlistment of members of the Hindu community to pose as Rohingya in an attempt to con the journalists into reporting that the Rohingya themselves were responsible. Mr. Head and his fellow journalists saw through the sham. The court can find his statement at Annex 375 of the memorial. The relevant paragraphs are 15 to 19. Mr. President, this concludes my presentation. Thank you for your kind attention. I ask that you invite Mr. Suleiman to the podium.
I thank Mr. Lowenstein for his statement. I now give the floor to Mr. Arsalan Suleiman. You have the floor, sir.
Thank you, Mr. President. Members of the court, good afternoon again. I will respond to Myanmar's attempt to persuade you that in attacking Rohingya civilians indiscriminately, engaging in mass murder, killing children and infants, raping and gang raping women and girls, burning homes and villages, and shooting and killing fleeing refugees, the Tatmadaw were engaging in authentic counterterrorism operations. There is no counterterrorism justification for the sickening genocidal acts committed during Myanmar's clearance operations. This conclusion is confirmed by the convincing testimony of the victim witnesses from the 3 main villages who fully corroborate the findings of the UN FFM. And that conclusion is also supported by the authoritative and conclusive expert testimony provided by Professor Michael Newton. I will respond to Myanmar's arguments and the questions from judges in relation to ARSA's capabilities and why Myanmar's clearance operations were not authentic counterterrorism exercises. I will then comment upon Myanmar's unreliable evidence. Before I do so, I raise 2 points. First, as my colleagues have mentioned, Mr. Staker has conceded that genocide can be committed during counterterrorism operations. That means that counterterrorism is mere context and not a viable alternative intent to genocide. Second, throughout the entirety of Myanmar's first round, not a single mention was made of the Arakan Army or any other ethnic armed organization. Not a single mention. That is quite remarkable and revealing, especially after the comparison I drew in the first round between the acts committed against the Rohingya community in purported reaction to ARSA and the treatment of the Rakhine and other ethnic communities in the context of the Tatmadaw's ongoing conflict against the Arakan Army and other ethnic armed organizations. Recall that the rules of engagement for ARSA and the Arakan Army are the exact same. Myanmar has provided no explanation for the difference in treatment of the Rohingya and Rakhine communities. The only reasonable explanation for the differential treatment is Myanmar's genocidal intent for the Rohingya. Now, turning to ARSA and its capabilities. Judge Brandt, also on behalf of Judge Charlesworth and Judge Cleveland, asked for the party's characterizations of ARSA's representativeness within the civilian population, its strength, estimated size, organization and hierarchical structure, and military and weapons capabilities. On this matter, the Gambia relies primarily on the reporting of the UNFFM and the IIMM, both of which provide independent and objective information on the capabilities of ARSA that included official information released publicly by Myanmar. Paragraphs 1009 to 1067 of the 2018 detailed FFM report are particularly helpful on this question. Regarding ARSA's representativeness and estimated size, the FFM reported that, quote, total numbers of members and supporters are difficult to ascertain. The actual membership seems to have been small, but the support base was certainly in the hundreds. This includes the last-minute mobilization of many Rohingya, with many of those who participated in the 25 August 2017 attacks mobilized only shortly before that day or on the day itself. However, overall membership and support for ARSA represented a minority of the total population, end quote. According to the FFM, quote, supporters claim to be motivated by the need to fight long-standing discrimination against the Rohingya and the denial of human rights. Some had personally suffered oppression and abuse by the Tatmadaw or other security forces, end quote. In any event, Myanmar's rules of engagement are still fully applicable, regardless of ARSA's size, as confirmed by the testimony of Professor Newton. Regarding ARSA's strength and military and weapons capabilities, the UN FFM reported that, quote, ARSA is commonly regarded as a poorly armed and poorly trained group, with a small number of partly trained members, but principally relying on untrained villagers to conduct attacks with sticks and knives. In comparison with the long-standing and well-armed non-state armed groups active in northern Myanmar, ARSA's level of organization and military capacity appears more limited, end quote. In terms of training, the FFM reported that, quote, a core group of ARSA members received some military training, including in weaponry. Some who had received weapons training then replicated it for others, although often without weapons, by using hand gestures and wooden models, end quote. Those who were, quote, mobilized shortly prior to the 2017 attacks had no training and little information about the group, end quote. As to weaponry, the FFM reports, quote, for the 2017 attacks, most ARSA members were without firearms, but equipped with homemade weapons such as sticks, knives, swords, and slingshots, and some homemade explosives. One ARSA member told the FFM that, quote, all they did was give us a stick and said that we should pretend that it is a weapon. We never got any training or weapons, end quote. The IIMM similarly found that at the time of the August 2017 attacks, ARSA only had a, quote, modest arsenal of around 40 to 70 firearms, end quote. The, quote, majority of ARSA members used bladed weapons, sticks, and a small number of locally produced artisanal firearms, end quote. Imagine how outgunned and outmanned they were by the thousands of heavily armed Tatmadaw who were awaiting them, having been pre-deployed across northern Rakhine State with automated weapons, mortars, and other heavy equipment. Does Myanmar really expect us to believe that ARSA intended to capture and control all of northern Rakhine State? In fact, they were quickly routed by the Tatmadaw and forced to abandon the field in less than 3 days, according to an IIMM witness statement submitted by Myanmar. Counsel for Myanmar mentioned IEDs, or improvised explosive devices, over 10 times in their first round. This is what the FFM found regarding IED use. Quote, ARSA did have some capacity to produce crude IEDs, but that capacity is questionable, both in terms of production and execution. As one ARSA member elaborated, the IEDs were made locally by members and are not particularly strong. We use them just to scare the military. In the attack in which he participated, the explosive was not directed at the checkpoint as intended, and no military casualties were reported. While the Myanmar government's list of ARSA attacks mentions the use of IEDs by ARSA, none of the casualties sustained by the Myanmar security forces were reported as having been caused by an IED, end quote. The FFM also noted that, quote, the government reported that during the 2017 clearance operations, it confiscated 15 assorted arms, 97 ammunitions, and 67 homemade IEDs. These figures demonstrate ARSA's weaponry capacity at the time, in particular when juxtaposed against the military capacity of the Tatmadaw, end quote. As to the nature of ARSA's attacks, the FFM reported that, quote, ARSA was able to carry out multiple coordinated attacks in a highly controlled and militarized environment, but with little military capability. The attacks employed hit-and-run tactics with predominantly untrained civilians, mostly wielding sticks and knives. The ARSA attacks caused minimal Tatmadaw casualties compared to their own losses, end quote. An ARSA participant in the 2017 attacks told the FFM of those attacks, quote, it was not really like a military attack by us. It was a protest or uprising, claiming our rights, end quote. Regarding ARSA's organization, the FFM reported that, quote, in its early stages, the organization did not have a name or clearly defined goals. It was loosely organized around the principle of seeking justice for the Rohingya Muslim community, end quote. ARSA's forces are organized hierarchically under a commander-in-chief, who is currently under arrest pending prosecution in Bangladesh. Myanmar did not even declare ARSA a terrorist organization until 25 August 2017, which gives an indication of its own assessment of its capabilities up to that point. Both Mr. Blom Cooper and Ms. Lowry stated that ARSA's objective was to, quote, obtain, quote, complete control over northern Rakhine State, end quote. Their citation to Myanmar's counter-memorial does not support such a claim. Curiously, they also cited to the FFM report. The paragraphs that they cited in that report also do not support their claim. And the very next paragraph in the FFM report directly disputes their position. According to the UNFFM, quote, while high-level Myanmar officials imply that ARSA seeks an independent state, homeland, or caliphate, the mission has not seen such statements from ARSA, end quote. Ms. Lowry stressed ARSA's use of WhatsApp to coordinate activities as a sign of its sophistication. Frankly, that just shows the opposite. ARSA, by the way, also had a Twitter account that it opened in March 2017, which is controlled by a political group made up of 5 people living outside of Myanmar. Both Ms. Lowry and Mr. Blom Cooper cited a call by ARSA's leader to burn down villages as part of the attacks. And both of them ignored the evidence that the Gambia cited to show that the call was not heeded. Recall that according to Myanmar's own source, Amnesty International, quote, While Amnesty International has confirmed that some Rohingya villagers participated in ARSA attacks, the overwhelming majority of Rohingya did not. Even in the specific villages where attacks occurred, there is no question that most villagers did not take part in ARSA attacks, end quote. Similarly, the International Crisis Group concluded that the ARSA commander's call to burn down Rakhine Buddhist villages, quote, does not appear to have been widely acted upon, as only 3 non-Rohingya villages are known to have been attacked or burned down by Rohingya, end quote. The fact that this call was not heeded shows the lack of support for ARSA among the Rohingya. The fact that 2 counsel for Myanmar ignored this reality shows the extent they are willing to go to concoct a sham defense for their client. Evidence placed into the record by Myanmar after the close of the written pleadings shows that Myanmar closely surveilled ARSA, knew about many of its members, and yet did not take action to dismantle the organization. According to the testimony of IIMM witness P4715, quote, it was well known that the authorities were surveilling ARSA and knew about its members. They found out about ARSA members from informants. Although the authorities received information about ARSA from informants, they never tried to dismantle ARSA. This has always puzzled me. I believe they allowed ARSA to exist because what they really wanted was to attack our villages and empty them. All of these factors combined have led me to believe that Myanmar government allowed ARSA to exist as a justification to keep persecuting us until we were gone, end quote. This is from Myanmar's own evidence. It was Myanmar that put this witness statement into the record, and they have to live with it. It is also noteworthy that Myanmar passed in silence on the undisputed evidence cited in the first round regarding the Tatmadaws' recent collaboration with ARSA to fight the Arakan army. Myanmar's efforts to trump up the threat posed by ARSA is undermined by its own manipulation of and collaboration with them. By all measures, ARSA was not of the same caliber of organization as the Arakan army or other ethnic armed groups in Myanmar. It was a fledgling group, never a match for the Tatmadaw, more of a pawn, and was used as the pretext for Myanmar's genocidal clearance operations. Regarding the second and the last parts of Judge Brandt's question, I note that the FFM reported on Myanmar's public accounting of its own and ARSA's casualties from the 2017 clearance operations. According to the Myanmar government's own reporting in November 2017, quote, 376 ARSA Bengali terrorists killed, 131 ethnic Hindu Bengali people, and 13 members of security force killed. And according to Ms. Lowry, quote, in terms of casualties from the 2016 attacks, the government estimated at the time that 69 ARSA terrorists, 7 Tatmadaw soldiers, and 10 police officers were killed, end quote. I move now to the clearance operations and why the evidence elicited at these hearings confirms the FFM's conclusion that they were not legitimate counterterrorism operations. First, Myanmar has not shown that it made even the slightest effort to distinguish between alleged ARSA terrorists and Rohingya civilians. Ms. Lowry asserted without evidence that Myanmar's references to supporters was to, quote, local villagers who, though not formal ARSA members, joined in ARSA's violence when called to do so. Active adult participants, she asserted. But how does she explain the killings in Tulatoli that witness MS testified about? How does she explain the burning to death of witness NJ's infant in Chutpin, or the gang rape that she endured? How does she explain the execution of over 80 men and boys in Maungnu as testified by witness MN, the sole survivor? How does she explain the evidence from Amnesty International and the International Crisis Group and the UNFFM that all civilians were targeted without distinction and that very few Rohingya answered the call of ARSA's leader? Perhaps the court will hear more assertions without evidence on Wednesday and Thursday, but there is certainly no evidence that the Tatmadaw made any effort to distinguish between civilians and ARSA as called for by Myanmar's rules of engagement. To the contrary, they purposefully directed their attacks and atrocities against all Rohingya. Regarding Myanmar's position that ARSA supporters comprise men, women, and children, Ms. Lowry asserts that children means youth in the rank and file of those confronting the military. Again, no evidence. Mr. Lowenstein has just fully addressed this point. Second, Myanmar has not shown that it provided protection to Rohingya civilians. Ms. Lowry excuses Myanmar's inciting and arming of ethnic Rakhine and encouraging them to join in the Tatmadaw's attack on the Rohingya population as a, quote, initiative to recruit non-Bengali citizens to a new regional force, end quote. Incredible. Why didn't they recruit Rohingya into such a localized police force? Why were the Rohingya excluded? The answer is obvious. They were always the target for those new militias. That was shown clearly in the video of the Tatmadaw soldier explaining the clearance operations to ethnic Rakhine, calling on them to arm themselves with swords to bravely face the, quote, animal Rohingya. Judge Pillay asked if counsel for Myanmar could provide examples of how, when, and where the Myanmar military protected the people. I will take the liberty of sharing the Gambia's answer. They attacked the Rohingya people, the exact opposite of protecting them. If some Tatmadaw units ignored some Rohingya as they fled the killing and the burning of their villages, they were the exception rather than the rule. You would have to believe the Tatmadaw's self-serving and unreliable daily operation reports and letters to find any claims that the clearance operations were undertaken to protect, quote, ethnic residents or to rescue the, quote, local ethnics / local natives in danger. Of course, the Rohingya were never considered as local ethnics, and there is no reason to believe the Tatmadaw's propaganda in any event. Third, Myanmar has not shown that it adhered to its own rules of engagement. Professor Michael Newton provided authoritative testimony last Thursday as to why he concluded that Myanmar acted with genocidal intent, based on Myanmar not following its own rules of engagement. I won't read all of his testimony back to the court, as I'm sure the court recalls it very clearly. But he said specifically, as part of this quote on your screen, I learned in the counter memorial that there were rules of engagement. They were not only not followed, they were completely ignored, which is the substantive basis for those statements, end quote. Myanmar also asserts that its clearance operations were conducted only in places where ARSA was active. The insinuation is that the operations were in hot pursuit immediately after ARSA attacks, following the ARSA attackers. But that is not at all how they played out. As explained by the UNFFM, quote, the security forces' response was immediate, within hours, brutal and grossly disproportionate, ostensibly to eliminate the terrorist threat posed by ARSA. In the days and weeks that followed, it encompassed hundreds of villages across Mongdal, Buthidaw, and Rathadong townships. The operations targeted and terrorized the entire Rohingya population. The authorities called them clearance operations. They continued for more than 2 months and for a considerable period after the government claimed their completion on 5 September 2017. During the course of the operation, more than 40% of all villages in northern Rakhine State were partially or totally destroyed. The most intense phase was the first 3 weeks, when more than 80% of the destruction was perpetrated." End quote. In the first round, I showed you reply figure 1.2, which shows that Myanmar wholly or partially destroyed at least 188 out of 329 villages where, according to Myanmar, there was no ARSA presence and so no pretense of clearance operations. Myanmar gave no response to that. It is evident that the clearance operations were not limited to areas of actual ARSA activity, but targeted the Rohingya all across northern Rakhine State. As Professor Newton testified, what happened during the clearance operations was not occasional lapses in soldiers following the rules of engagement. It was a wholesale disregard, a completely different intent and plan, a genocidal plan. This was the same conclusion reached by the Public International Law and Policy Group, which concluded, quote, "The investigators also highlighted the likelihood that the military operation could not have been merely a response to the ARSA attacks, debunking the military's narrative of a legitimate counterinsurgency response. The scale, timing, and consistency of the attacks across such a large territory could not have been planned and coordinated in such a short period of time within a few days of the last ARSA attack. The pretense of a clearing operation to protect the state from a Rohingya terrorist insurgency threat rings hollow in the face of so much of this data." End quote. I come now to my last topic, which is Myanmar's evidence. Myanmar did not produce any military officers or experts for oral examination. They initially included a few of them on their witness list, but then withdrew their names before these hearings. Most of Myanmar's factual claims regarding the clearance operations are based primarily, or sometimes solely, on Myanmar's own military reports or testimony from officers or testimony of individuals taken by the military. These sources of evidence are not reliable or independent. The Myanmar military's overriding interest to protect itself taints the credibility of these sources of evidence. As Professor Newton testified, this is true of other militaries across the world. Military reports are, in his words, absolutely unreliable. There is testimony in the record of Myanmar military reports being fabricated, to which Myanmar has not responded. The IIMM screening note for P5513 details such a fabricated report. In fact, Myanmar has not responded to several fabrications of evidence by the Tatmadaw. There were the fabrications of images seeking to depict Rohingya as aggressors and illegal immigrant invaders in the Tatmadaw's post-clearance operations publication. There is the fabrication of images purporting to depict Rohingya burning their own villages, which was in fact members of the Hindu community, as Mr. Lowenstein just discussed. First-hand testimony confirming this has been provided by BBC journalist Jonathan Head. In his affidavit, he also recollects how, during a government-approved trip to Mongdao after the clearance operations, the military forced an individual from the Hindu community to falsely report that Muslims, rather than the military, had attacked their village. Which brings us now to witness M1 and the Kha Maung Sek incident, the primary example on which Myanmar relies as an example of attacks by ARSA requiring a substantive counterterrorism response. You heard from witness M1 on Friday that around 99 Hindu villagers from 2 adjacent villages were killed there on 25 August 2017. Her statement was not obtained by an independent source, but by Myanmar itself. It is unclear to the Gambia whether witness M1 actually appears in the video that Myanmar played twice last Friday. In response to questions from the president, counsel for Myanmar was unable to specifically identify witness M1 in the video or in the transcript. Today, by letter from Myanmar's agent, we learned that witness M1 did not speak in the video, even though her affidavit seemed to indicate that she did. It is notable that the first accounts of this tragic incident that survivors gave were that the military and/or ethnic Rakhine had attacked the village, a village which, the witness said, was predominantly Rohingya. It was the Myanmar authorities who first attributed the attack to ARSA, announcing so in early September 2017. They then repatriated from Bangladesh the Hindu survivors back to Myanmar, including witness M1, housed them at a Tatmadaw military base, and publicized the accounts that the survivors then gave, that it was ARSA terrorists who were responsible for the attack. Given Myanmar's history of using the Hindu community in Rakhine State to support the military's false narratives, due caution is warranted with regards to witness M1. In these circumstances, it is not surprising that the UN FFM considered itself unable to draw any conclusions about what happened at Ka Maung Sek. In its 2018 detailed report, it said, quote, "The mission interviewed 7 Hindus from Ka Maung Sek and nearby villages who witnessed these events or were victims of abuses in September 2017. The mission has verified that a large number of Hindu victims were killed on 25 August 2017 in Ka Maung Sek. However, the information received was contradictory, including regarding the language spoken by the perpetrators, which, according to the accounts taken, was a key identifying feature since the perpetrators reportedly had their faces covered. The mission's information is insufficient to make any determinations on reasonable grounds regarding the identity of the perpetrators." End quote. In the end, even if ARSA were responsible for this massacre, this would have no bearing on the Gambia's case. The perpetrators of the Ka Maung Sek massacre should be brought to justice, just as Myanmar itself must be held accountable for its genocide of the Rohingya. In conclusion, Myanmar's clearance operations violated all of the fundamental tenets of legitimate counterterrorism operations, including Myanmar's own. They were not authentic counterterrorism operations. The ARSA attacks were, in fact, a pretext for Myanmar's genocidal attacks on the Rohingya. Mr. President, members of the court, thank you for your kind attention. Mr. President, I request that you call Professor Darjan to the podium to conclude the Gambia's presentations for today.
I thank Mr. Suleiman for his statement. Je donne à présent la parole au professeur.
I now give the floor to Professor Pierre Darjan. You have the floor, sir.
Merci, Monsieur le Président.
Thank you, Mr. President. Mr. President, members of the court, my presentation will deal with the destruction of evidence and impunity. The pleadings of Professor Miron on these matters was lengthy and quite dense, replete with accusations of inconsistencies or errors of law regarding relatively simple matters. Allow me, therefore, to straighten things out one last time. As you know, we are saying 2 distinct things on this matter, 2 things that are distinct but complementary. Impunity and destruction of evidence are, on the one hand, and above all, indicators of genocidal intent. Now, why is that? Well, it is because they both result from state action and contribute to the manifestation of a state's policy. Such a policy is at the heart of the notion of dolus specialis, when the responsibility for genocide at stake is that of the state. Myanmar claims that in the Croatia case, the court, and I quote, ruled out impunity as an indicator of genocidal intent and presented on the first day of its pleadings a table with coloured arrows that you might remember, a table with coloured arrows to support this assertion. But this is inaccurate. The court said nothing on the matter and limited its examination to the criteria it believed to be the most important in that case, as Mr. Suleiman recalled earlier. And the court concluded its reasoning on genocidal intent by referring, and I quote, to the series of 17 factors invoked by Croatia, without having ruled out any as a matter of principle. Myanmar purports that the behaviour that follows genocidal acts cannot, and I quote, retrospectively shed light on the nature of the acts that preceded it. That is also wrong. Indeed, in the same case, the court underlined that state behaviour, and I quote, before, during, and after the military operation in question was relevant to rule on the dolus specialis of the state. The way in which Myanmar acted after the clearance operations spectacularly highlights its genocidal intent, because the impunity that follows the exactions directly benefits those who perpetrated them. In this regard, the legal characterization of the offences being prosecuted are of no importance. It is enough to see that there were no inquiries, prosecution or sentencing commensurate to the facts under any criminal charges. What's more, if the court finds that a genocide did take place, we put it, in a distinct but complementary way, that destruction of proof and impunity amount to violations of the obligation to punish under Article 1 of the Convention. Professor Miron stated that this was circular. But there's nothing circular here, members of the court. We are simply drawing the logical legal conclusion. Indeed, proper compliance with the obligations of Article 1, that is to say, the obligation to prevent and the obligation to punish genocide, proper compliance with these obligations imply the opposite of genocidal intent. Having recalled this, I come to destruction of evidence and impunity as confirmatory indicators included for the sake of completeness of Myanmar's genocidal intent and of members of its military benefiting from impunity. Concerning the facts connected with destruction of proof, Professor Miron said practically nothing. The court confirmed in the well-substantiated September 2025 IIMM report that you have in tab 7 of your file, the court confirmed that this was validly placed into the record as publication readily available. Myanmar chose not to say anything on the matter. Concerning the destruction of corpses via incineration or acid, Myanmar criticizes us for blindly trusting, I quote, blindly trusting an article of the Associated Press. Really, should we recall the testimony of witness NJ, whose baby was ripped from her arms, stabbed and thrown into the fire, or the testimony of witness MS, who saw large pits being dug in the sand in which corpses were thrown, covered in dry leaves, doused with a flammable liquid and burnt, which confirms the facts established by the FFM. Myanmar did not contest, and I quote, the possibility of the existence of burned bodies in mass graves. but it attempted to explain this practice via the local context, including weather conditions and alleged health concerns, to avoid contaminating water sources. It referred, Professor Miron referred to the statement by witness P5513 that we have attached in tab 8 of your file. This witness tells of the existence of human remains in water basins, making the water unfit for consumption. Myanmar chooses to ignore the rest of this testimony, but claims that on that basis, incineration of the victims of its crimes is justified. It will be for the court to decide. But the truth is much simpler, and everyone understands it. Bodies buried in a mass grave could still be exhumed years later, but burnt bodies go up in smoke and are gone forever. When it comes to the burning of villages to ash and their bulldozing, Professor Miron claimed that many of the villages that appear destroyed on satellite imagery had not seen any fighting, and asked the following question: what crimes could we have been hiding, or could have been hidden, in locations where there is no allegation of genocidal acts? End quote. The answer is obvious. No other crime than the act of destroying these villages with no military purpose other than destroying the group. Concerning the impunity as an indicator of genocidal intent, Professor Miron hides behind, and I quote, the constitutional autonomy of states, and she believes that the Gambia, and once again I quote, is complaining about the fact that prosecution by military courts is insufficient in principle because it is not subjected to civilian control. But no, that is not what we are saying. We are saying that since the Tatmadaw is accountable only to itself, even having committed unspeakable atrocities, its impunity is immediately accessible to it without any legal obstacle or control, making genocidal intent all the more obvious. This is not a theoretical question. The fact of the matter is that no prosecution was started against the high-ranking officers who planned and ordered the 2016 and 2017 operations, nor was there any prosecution against those who obeyed, which shows how ineffective the system is, except to cover up crimes. My learned colleague also believes that we are complaining about insufficient sentencing. Now, if she is referring to the removal of some years of seniority for the purposes of calculating pensions, she is absolutely correct. That is a laughable sanction. However, if my colleague is referring to the 10-year custodial sentence for the Indian massacre, she is wrong. It is not the sentence we are criticizing, but the presidential pardon that was granted to the military personnel only 7 months into their sentence. This was a prosecution that cost Reuters journalists their freedom and only came about after Burmese military courts initially denied any incident had taken place in that location. Now, Professor Miron no doubt believed that she was defending Myanmar when she highlighted its national authorities' powers of inquiry and prosecution, and powers of discretion there. We do not deny that, to a certain extent, this power exists. However, members of the court, even assuming that there existed a degree of discretion in prosecution, the inevitable conclusion of the reasoning presented by my learned colleague is that Myanmar did indeed choose impunity. This impunity is thus part of a state policy aimed at rewarding the perpetrators for fully embracing and executing the genocidal project of the highest state authorities.
Par ailleurs,
Moreover, Mr. President, it's one thing to do nothing, but it's something entirely different to do everything to give the impression you are doing something. And that is exactly what Myanmar has done. It pretended it was investigating. For show, it set up fake inquiry board after fake inquiry board. And what did Professor Miron say? She did not challenge the facts I recounted, nor did she challenge the timeline, which we feel is particularly relevant. She brandished the Mangdor Commission and the Independent Commission of Inquiry, whose so-called investigating efforts I mentioned previously. Now, does what she says undermine the evidence of a system of impunity deliberately organised by Myanmar for the benefit of its henchmen and thus confirming genocidal intent? Absolutely not. The final conclusions of the Mangdor Commission, which my colleague refers to, speak for themselves, and they have led to no prosecution, no sanction. On the contrary, they have led to a botched investigation by the Tatmadaw, stating that the contemporaneous UN allegations were, and you'll remember that, totally wrong and untrue. My colleague also mentioned the so-called Independent Commission of Inquiry established in July 2018. As I showed during the first round, with this commission, it's really much ado about nothing. Professor Miron did not challenge the accuracy of the numbers that hasn't moved and changed over the last few years, in which I mentioned, relating to the so-called investigation and prosecutions of police officers and servicemen, a tally that I derived from the twice yearly reports from Myanmar. Mr. President, this brings me to destruction of evidence and impunity as a violation of the obligation to punish under the Convention. I can do that briefly. First of all, this obligation is exclusively territorial as an obligation and subject to the request for extradition under Article 7, the Convention as a whole is not an instrument of interstate criminal cooperation. I note Myanmar acknowledges that the obligation to punish includes an obligation to investigate and an obligation to prosecute. Myanmar claims that the obligation to punish is an obligation of conduct, not an obligation of result. Without conceding, I will let the court decide and rule on this theoretical discussion. But I can understand that criteria must be met to trigger the obligation. But once it has been triggered, then the result is required. A result is required. In any case, you cannot seriously argue that Myanmar has made its best efforts to prosecute and punish crimes committed on its own territory by its army. So the theoretical discussion about the nature of the obligation to punish leads us nowhere, apart maybe from leading us to say that should Myanmar be found responsible for genocide, then self-evidently it is also responsible for failing to comply with the obligation to punish the masterminds and perpetrators of the genocide for any of the acts listed in Article 3. By and in destroying evidence of such actions, Myanmar most certainly did not show the due diligence which, according to Professor Miron, applies to this obligation to punish. Myanmar also states that the obligation to punish was not triggered because Gambia hasn't, and I quote, demonstrated that a genocide has likely been committed, as it didn't sufficiently identify the geographical location of the facts and the identity of the alleged perpetrators of the alleged genocidal act. End quote. Mr. President, members of the court, must we really respond to this? The obligation to punish is a territorial obligation, and Myanmar controls its own territory. There is no need for a third party to inform it of what has happened at home or to give it any information of what has happened. We have acts of violence known across the world, documented with extreme professionalism by UN bodies and perpetrated in Myanmar. And Myanmar would be unable to investigate and or prosecute for lack of specific identification of location of the actions or of the identity of the persons. But it is Myanmar that knows who its soldiers are. Myanmar conducted the military operation in the villages whose names it has voiced here in court. Ladies and gentlemen, members of the court, I had said in our first round of pleadings that Gambia was not requesting the court institute a presumption of bad faith on Myanmar. Having heard their arguments, the arguments of Myanmar, you probably thought I had been too generous. Rightly so. To say that the obligation to punish is not applicable to military commanders under the Convention is yet another surprising, particularly surprising legal proposition. Must I read out Article 4 of the Convention that mentions constitutionally responsible rulers and public officials? Or must I recall Article 3, which imposes a requirement to punish conspiracy and complicity in genocide, not only personal perpetration of acts listed under 2A and 2B? And what of acts listed under 2C and 2D? Can you inflict destructive conditions of life on a group and prevent births within a group without the perpetrators organising themselves and therefore without decisions from their superiors? The authors of the Convention have obviously included within it the superiors. In fact, it feels like Myanmar is seeking to get from the court an obiter dictum clearing the head of the junta and its accomplices of any responsibility under the Convention. Mr. President, in this respect, Myanmar's defence is desperate, legally wrong, and, let me say it, disgraceful. I haven't got much time, unfortunately, to mention the obligation to enact legislation under Article 5, but can I refer you to our written submissions and to what Ms. Jones has said here in court. Professor Miron on this topic, however, claimed that Gambia is requesting the court, and I quote, to pass judgment on the conventionality of Myanmar's domestic law, which, and I'm still quoting, goes beyond the nature of your judicial function. She mentioned the constitutional autonomy of states and the legal and cultural differences between states party, end quote. By asking you to state that Myanmar did not comply with its obligations under Article 5, the Gambia in no way is denying these differences that the drafters of the Convention quite clearly had in mind when they were drafting Article 5. But on this too, there is a dispute between the parties relating to the interpretation, application or fulfilment of the provision. And the court undoubtedly has the power to say that a state has failed to comply with its obligations were that to be the case. Can I, by way of conclusion and for a comprehensive presentation, mention that the destruction of evidence after the 23rd of January 2020, that is after the judgment on the order on interim measures that Ms. Al-Amin mentioned, is clearly an internationally wrongful act, regardless of the existence of a genocide, as they go against the third provisional measure indicated by the court. According to Myanmar, our allegation rests entirely on the oral account by the United Nations High Commissioner for Human Rights. That is wrong. Wrong indeed. We have other evidence including the September 20 report by the UN Special Rapporteur on the situation of human rights in Myanmar, and the September 2025 IIMM report, which the respondent refuses to respond to at their own expense. Ms. Alamin also responded to Myanmar's denials allegedly resting on NASA satellite imagery. Can I add that these images were never submitted to the court in this approach, and that indeed Professor Miron acknowledged it. The pictures only covered Butidong Township until July 2020 and no later. Isn't that, honourable members, particularly bizarre? And I thank the court for its kind attention.
Professor Daljan, for the statement, brings this sitting to a close. The oral proceedings in the case will resume tomorrow, Tuesday, the 27th of January 2026 at 10 a.m. when the Gambia will continue its second round of oral argument. The sitting is closed.